Do you agree that Billy Chitwood is an adult?
Yes, I do agree that he's an adult. We've sent a copy of his conviction records.
Do you agree that he should be responsible for his own actions with respect to the way that he interacts with you and your guests on your property?
With respect, he should be held accountable for his actions, particularly the criminal ones, but this does not obviate Ms. Chitwood's responsibilities as were set forth in the injunction.
Okay, you're talking about the injunction. I want to zero in and understand specifically what you are alleging she has violated with respect to the injunction. What is your position that she has violated when it comes to controlling the actions of a third-party adult or adults?
As the owner of that property, she has the ability to remove or have removed from it anyone who places her in jeopardy of thousands of dollars in fines and or jail time with the police if necessary, and she elected not to do so on numerous occasions.
Can you point to the specific provision in that injunctive order and a default judgment that required her to remove individuals from her property, particularly family members from her property?
No, and with respect, sir, I think that's a red herring. I was simply responding in kind to your question about what would a reasonable adult be expected to do. I know that in my situation here, if I were enjoined from allowing certain activities to take place on my property, and if I instructed someone not to do so and they refused to heed my instructions, then I would have them removed. But this is supposition on my part. And again, I also feel as if I object to this question, it's cause for speculation. You're asking me to read the mind of another people. You're asking me, again, questions about whether or not I had access to conversations or could definitively prove a negative or prove that she did or did not do something, which is a scientific impossibility. But I believe that the directions in the injunction are very clear.
Can you identify any, with respect to the conduct on March 23rd, 2022, can you identify any specific law that Ms. Curry was allegedly in violation of during that incident?
Sorry, one moment, please, counselor. With respect, my sweetheart has just handed me this, and I'm reading the second of the injunctions in the injunctive release section of the original judgment, which says Tracy Curry Chitwood is ordered by way of mandatory injunction to instruct here Sir Justin Chitwood and any other person upon the property to refrain from committing any acts reasonably calculated to cause discomfort or annoyance to persons of ordinary sensibilities attempting to and enjoy the plaintiff's property at 202 West Wheeler, Manor, Texas. I believe that that is a fairly direct and straightforward and comprehensive answer to your questions about what her obligations are.
Then would you agree that if she is to have admonished, if she is to have directed, I want to make sure I'm getting the general language right, directed Mr. Chitwood and any other person on the property to refrain from committing such acts, that she would be compliant with her obligations under the default judgment?
No, I disagree. And at the risk of, I'm not being argumentative, but this reminds me very much of Bill Clinton's, it depends what the definition of is. The operative word in that sentence is directed. And as the owner of the property, she is instructed to direct, and that includes directing people off of the property. We could, of course, waste the court's time and open up the online version of Merriam-Webster's dictionary to confirm that. But again, I think this doesn't need to happen.
Okay, I want to get back to the facts. March the 25th, which I think is alleged in paragraph 10.
Yes, sir.
Excuse me, paragraph 11, March 26th. I apologize. So focusing on March the 26th, and I believe this was some of the testimony we heard this morning from a friend of yours. Is that right? I've forgotten his name.
You're referring to Mr. Tate?
Yes.
Yes, go ahead, please.
In regard to this incident, I again want to ask, did you personally see any?
Sorry, I apologize. Allow me to interrupt you. That was incorrect. March 26th was brandishing the AR-15 in front of the workers. And I will say for the record that one of those workers subsequently refused to return. The work was finished by the other one. The incidents involving Mr. Tate were on March 27th.
Okay, thank you. Yeah, thank you for clarifying that. All right. So then with respect to March 26th, do you agree that you personally did not see this alleged firearm that's referenced here in this allegation? Do you agree with that?
No, I absolutely do not. In fact, the judge asked me that question rather pointedly, whether or not I saw it, and I believe that I gave a very thorough answer about looking directly at it and seeing it produced not once but twice.
You personally saw the firearm. Where were you when you saw it? Is that?
I believe I've already answered this as well. I was standing in my doorway. The ring camera is at a height that's insufficient to see over the fence. However, I'm 2 feet taller and I was able to clearly see over the fence. Saw the firearm produced, carried into the residence at 207, and then carried back out to be brandished again in front of myself and the workers, before again being placed back into the truck, and the truck eventually going over to 106 West Wheeler.
And you did not see Miss Curry outside the house, correct, at that time?
Can you narrow this down in terms of, did I see Miss Curry outside of the house on the 26th?
Yes, that's the question.
Do we have that somewhere? I don't want to misspeak. Can I double check this, Your Honor, and then come back and respond to this at another time, perhaps tomorrow?
Yes, I do remember we had some video testimony or video clip showing
That's
Ms.
correct.
Curry's presence. I thought it was on the 27th, but I may be wrong. So yes,
And,
why don't you check on that, make a note of it, and come back and answer it tomorrow.
Thank you.
Mr. Savage, proceed.
All right. Whether you saw Miss Curry or not outside, did you see her on this instance in March 26th doing anything to engage, facilitate, or allow somebody to actually do this misconduct that you've alleged regarding a firearm?
Sir, with respect, again, you're asking me if I saw her do something to allow someone to commit activities. And it's now 6 times or more that I've answered that same question. I will reply with my same answer. She is under an injunction to not allow those things to happen. And the fact that they did happen, by extension, means that she allowed them to happen. With regards to you repeating the question of, did I see her on the property in March 26th? I've just asked and answered that and been granted time from the judge to double check records and video and give you an answer tomorrow.
Do you know who lives at the house?
Yes, I do, sir. Ms. Tracy Chitwood Curry lives there, and her son Justin lives there. The two of them have lived there since I purchased this property approximately 4 years ago. They have lived there during that entire time. I will say for the record, and I'm happy to be cross-examined on this tomorrow, if possible, that Ms. Curry Chitwood is largely a shut-in. And we had prepared evidence as part of Brent Orman's testimony with regards to the snakes, which was not allowed into court, which I completely understand. But we have already uploaded proof of the failure to leave the building, failure to take out trash for 6 months, et cetera, et cetera. That's already been uploaded. And if we have time, then I would be very happy to present that to the court. So we do not see her every day, but we see her there regularly enough that we know that she has been in a constant residence there, including ambulances arriving when she's had various episodes. I don't know any of the details of those episodes, but we do know that she has been in residence and very rarely ever leaves that property.
I'm going to object as non-responsive. The question was, do you know who lives at the house?
You asked a supplementary question, which, sorry, I apologize. If I did something wrong, I apologize.
No, look, here's the situation. Just answer his question.
Okay. I do know.
Who?
Tracy and Justin. And Billy was off and on for probably 6 to 8 months a year until fairly recently, about maybe 4 or 5 months ago.
And this individual you've alleged, I think you presented some information or evidence about Adrian Estrada. Is that right?
Yes, sir. Yes, sir.
That individual does not live at the house, right?
No, but he's there regularly. And if we have time today, we will play videos showing him engaging in the same offensive behavior.
With respect to the incident that I believe was on February the 24th, specifically I'm referring to, I think it was actually P119, a video that you introduced involving a truck that had some tire skid marks or something of that sort. That truck, was that Miss Curry's truck, to your knowledge?
No, that was William Chitwood's truck, but usually parked on her property.
Have you actually been over to Miss Curry's home before?
No, her property is marked no trespassing, and I have no intention of being shot or cited.
Have you ever knocked on the door or been close to the house?
Again, sir, there is a no trespassing sign that is prominently displayed. We have had issues with
He's answered that question. He's answered that question. He has not been. There's no trespassing sign. Go ahead.
Has Miss Curry been over to your house before?
Yes, she has.
When was that?
It was when we first bought this property. A short while later, she came over accusing me of mail theft and also asking why we had thrown her family member out into the street. Presumably, her family member used to rent one of these units before we bought the building and thoroughly renovated it.
Did you throw her family member out on the street?
No, absolutely not. I purchased the building, which was in a state of extreme disrepair. The foundation had to be leveled. The sewage lines had to be reconnected. It was uninhabitable for a period of several months. We rented an apartment ourselves for 4 months while that work was done. So it was simply a matter.
The answer is no. You did not throw her family member.
Did not throw her out. Okay.
Okay, go ahead, Mr. Savage.
Okay, with respect to all the allegations, just globally, because I just want to make sure that we're on the same page. Have you ever personally seen Ms. Curry actively encouraging somebody to do any of the misconduct that you have alleged today on this in this matter?
No, absolutely not. I've never seen her actively encourage anybody to behave offensively.
Thank you. No further questions.
Mr. Chitwood, do you have any questions for this witness? If you do, you're gonna need to come on camera and come on microphones. You don't, you can.
Not today, Your Honor.
All right, very good. All right, thank you. Mr. Wilner, call your next witness.
I'd like to call my wife, Laura, please. She's going to go into the other room where her computer is waiting.
Okay. All right, let's see, Ms. Wilner. Hang on a second. Can you hear me? Your microphone.
Yes, I can.
Okay, very good. All right, so I'm going to ask you to take an oath, and then we're going to get some testimony from you. Okay? Do you raise your right hand? Okay. Do you solemnly swear or affirm under penalty of perjury that the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
I do.
All right. You may proceed.
Okay, so I guess, sweetheart, I'm going to ask a couple of sorry, I apologize. I guess, Mrs. Wilner, I'm going to ask you some general questions first. What is our living and working arrangement like?
We live at 202 Wheeler, which is also a rental property. So we live and work at the same place.
And so how often are we together?
We are together most of the time, and most of the time it is here on this property.
Okay, and by most of the time, those exceptions would be when you walk the dogs or when you're in one of the other units cleaning.
Right.
Okay. In the interest of time, I'm just going to ask you, what has it been like? Oh, so first, before that, you've heard all of the testimony that's been given today. Were you a witness at all of these? Were you a witness of for instance, the issue with the AR-15 being paraded on countless occasions, numerous occasions, I should say?
Yes, I was present with the AR-15 being paraded around. It was when the workers were installing the patio. I saw it that day when Billy Chitwood and Adrian Estrada were walking between the properties at 207 Wheeler and 106 Wheeler.
Okay. And all of the testimony that's been given so far, trying to be mindful of time, do you corroborate all of the evidence that's been given by my
No,
witnesses?
you're going to have to. I won't allow that.
Okay.
I won't
All right.
allow that. No, you got
Okay.
it. She's going to have to go through it. Just stay in order. Go through your timeline.
Okay.
You'll get through it. But I'm not going to say or corroborate everything. No.
Okay.
No.
So, all right, sweetheart, where were you on January 1st when the fireworks issue took place?
I was here and saw Billy shooting the fireworks at the 207 property.
Okay, and did you hear the phone calls as well?
Yes, I heard the 911 calls you made.
Okay. In the interest of brevity, we're going to move on. What about on February 14th? Can you describe that evening of the drug deal gone bad?
It was around 11:30 at night. I was in bed watching a show when there was a loud pounding on the door, which got both of the dogs up and barking. I looked out the window and recognized Adrian Estrada, who came running onto the property with a bat and hit a bald, shirtless man that I didn't recognize. And there was also a third man who I've seen living at 207. And I called 911 immediately. Both of us, we stayed inside until we heard the police come, and they saw Adrian, who was walking on the road in front of our property, and asked him to drop the bat, which he still had, and put him in cuffs. And we also heard the canine unit come and came around our property and had the dog sniffing. We could hear them yelling out for the shirtless guy who had had a knife on him, trying to locate him. It was quite a terrifying night having that happen and being at our door.
So can you talk a little bit about the one? Okay. So you're confirming the version of events which has been previously provided to the court?
You don't need to do that.
Oh,
I
okay,
can hear
okay.
what she's saying. You don't need to
Okay.
you don't need to, just keep
All right.
going. This is what I'm talking
So,
about.
February-
Some testimony out is good. Go.
Yes. So, sweetheart, we didn't end up actually providing
Please
a
refer
lot
to
of.
her. She's not sweetheart.
Oh, sorry.
She's
I
got to be
apologize.
Miss- She's
I-
got to be Miss Wilner. And these people that you're calling Billy and no, they are William Chitwood and Justin Chitwood, and she's Ms. Wilner.
Yes.
Okay, because
Ms. Wil-
otherwise our record's not good, and y'all are paying for the record. So go and let's get
Ms.
it right.
Miss Wilner, can you briefly describe the incidents on February 15th so that they are in the record? Regarding the continuously pacing back and forth. Oh no, we've already done that. That was the AR-15. Moving on to March 9th, the issue of the firearm being discharged. We have entered as much information as we can with regards to those events, but I would like for you to talk about the emotional impact of watching this back and forth between these two properties, accelerating over the course of these 4 years to the point where we have shots fired and people banging on our doors. What's the impact been in your quality of life? And what's your assessment of that? What's your recounting of that firearm being discharged?
Okay, that's like 6 questions. So here, let me help you with this. Let's leave her emotional distress out of it. We can almost
Okay.
tell you it's going to be substantial. Okay. Talk to her, ask her about the firearm being discharged. What can she remember about that night? That's a good question, but just one question. Okay.
Okay.
Not 3. All right.
All right.
Please go ahead. Ask her that question.
Yes. What can you remember about the incident with the firearm being discharged, Ms. Wilner?
It was in the afternoon. I was taking the dogs out for a walk, and there was a lot of activity in the street. A number of cars driving past our place on Wheeler and also on Caldwell, where our corner is with 106. And there was a guy on the street walking by as well. I I walked down the street and when I came back, there were a lot of police cars in the road who had driven up. So I wasn't home at the time. I was on the walk. I don't recall hearing the shot. There were a lot of loud noises and construction on. So I may have heard it and just thought it was the construction. But
Okay.
when
On
I
the
got
judge's,
all the police cars and ambulance and found out later what exactly had happened.
okay, on the judge's advice, I'm not going to ask you questions about your feelings on that. Moving on to March 12th, Justin, I'm going to skip over the drug deals for the same reason. On March 22, defendant Tracy Curry allowed Justin Chitwood and Billy Chitwood to use the property to shout at and intimidate plaintiff and plaintiff's property.
I'm sorry, can you repeat that and slow
Yeah,
down?
these are just too fast.
Yes, Stephen.
Just slow down a little bit.
Okay, Ms. Wilner, on the March 22nd, when defendant Tracy Curry Chitwood allowed Justin Chitwood and Billy Chitwood to use the property located at 106 West Wheeler to shout at and intimidate plaintiff at plaintiff's properties. Can you confirm that also took place as described?
Yep. March 22nd was at night. William Chitwood and Justin Chitwood were outside at their property. I believe it was when you took the dogs out at night for their business run, and there was shouting over at you. I don't recall exactly what was said, but all of the times that they have yelled over, there's always been profanity and name calling, and it's never a pleasant conversation of hi, how are you?
Right. Okay. On March 23rd, the defendants allowed Billy to use the property to blare loud music from his truck for 8 hours while parked in the driveway in such a manner with its doors open facing our property in such a way as to direct music away from defendant's property at 106 and instead direct it across the street at plaintiff's property. These deliberate acts reasonably calculated to cause discomfort and annoyance. Can you confirm that? This is number 8. Can you confirm that, Ms. Wilner?
Yes, I do recall that day that the music was very loud. This has happened on several occasions, many days where the music has been blaring that we can hear it inside here. So it's clearly not just for their enjoyment while they're on their property, playing, doing things on their property. It's loud enough that it can be heard inside of our property, and there's no need for it to be that loud unless it was trying to annoy us.
And we can say for the record that we used a decibel meter and it was well in excess of the city's guidelines on that. Can you also speak to number 9 on March 24? Defendant Tracy Chitwood again allowing to blare loud music from his truck while parked in the driveway. Furthermore, allowing William Chitwood and Justin Chitwood to shout at and intimidate plaintiff and his paying guests at plaintiff's property. Can you confirm that is the videos that we've presented to the court, and that account of events is correct?
Yes, I was also there that day and they were still blaring the music. I don't recall exactly which day it was that we did call the police to do a drive-by and ask them to turn the music down. After we made the phone call in, I believe it was the 23rd in the evening. The music did get turned down, so when the police drove by, it wasn't playing loudly enough for them to stop and make any sort of questioning or citation.
And this was an occurrence that happened more than once, calling into the police and having the music suspiciously drop in volume a few minutes before the cruiser arrived, correct?
Correct.
Okay, moving on to number 10, March 25.
Just
sorry?
going back to the 24th about yelling when we had the two guests. I was in Unit A, so next door to ours, getting it ready for our next check-in, and I heard the shouting from in there, and that's when I came out when you were talking to the guests, and I came out to see what was going on, and heard the guests who were very upset at the shouting that was going on, and they were concerned for their safety. They had asked if they could pull their car up onto our lawn to unload their bags, which seemed very odd to me because they were both 6 feet tall guys in good shape, that if they were intimidated by these guys shouting, that it's never a good feeling as a business owner, someone staying at our place. We want them to be comfortable, and we try to ensure all our guests that everything is fine and safe, and meanwhile knowing that we also do have these problems and hoping that nothing bigger happens than just some shouting while guests are staying with us.
And thank you for that. And just to loop back very quickly, in the night of the banging on our door and you looking out the window, me grabbing the shotgun, etc. We did not have the opportunity today to play another camera angle showing one of our guests exiting an upstairs unit and looking down. Can you confirm for the court who that guest was and what they were doing in Manor?
His name was Kevin Yarnell, and he was a head contractor with Ryan, who is building the Whole Foods warehouse here in Manor. He had been staying with us for several weeks, and rather than continuing to stay with us after that incident, he did not renew his contract to extend his stay further as he had been.
Okay, thank you. So we did in fact lose that contract and any other follow-on contracts from it. Moving on to, where were we, 25? Let's see. Yes, did we do number 10 yet? Yes, number 10 on about March 25th, defendant Tracy Curry Chitwood allowed Billy Chitwood to shout from the William Chitwood to shout.
Slow.
On or about March 25th, 2022, defendant Tracy Curry Chitwood allowed William Chitwood to shout from the property 106 West Wheeler. This action was reasonably calculated to cause discomfort or annoyance to persons of ordinary sensibilities. Can you share your thoughts and comments on that, Ms. Billner?
You said it was the March 25th.
Yeah.
Um,
That's fine. We can come back to that one if we need to, in the
keeping
interest of.
the dates in my head straight of what happened when.
Yes, and there have been a great many dates. We only chose a few. Your Honor, far fewer than even 10%. Let's move on to March 27. March 26th. Defendant Tracy Curry Chitwood allowed William Chitwood and Adrian Estrada to use the property located at 106 West Wheeler to brandish an AR-15 in front of plaintiff's workers. You've already spoken to that, Ms. Wilner. So I think we can move on from that. On or about March 27, we're on number 12 now. Counselor, defendant Tracy Curry Chitwood allowed William Chitwood to throw a golf club from the property located at 106 West Wheeler. What is your recollection of that afternoon, acknowledging in advance that you were not outside of the building at the time that the golf club incident took place, but were in fact inside of our unit looking out these windows? Can you recount your recollection of the golf club throwing event, please?
As you said, I was inside, so I couldn't quite see everything. It was after he threw the club, there was a bit of a commotion, so I looked out to see what was going on, but I didn't see him actually throw the club personally. Okay,
so you only saw the recollections, or heard the recollections of Chris Tate, and then saw some of the same video evidence, or more video evidence actually, than the court has seen today. Later on that day, with the incident with the firearm, can you recount your recollections of that? Yes, this is number 12. Can you recount your recollections of the issue with the AR-15 and the interaction between William Chitwood and Chris Tate?
We were having dinner at our place with Chris Tate, his wife, and their baby. I do recall that after dinner, I took the dogs out for a walk and saw both William Chitwood and Justin Chitwood at 106 Wheeler, and they made a lewd comment as I was walking by with the dogs. I know that we subsequently tried to find that video clip on the security camera, and it wasn't there. The camera hadn't caught it. But I very clearly remember them yelling over at me.
And was that, Ms. Wilner, was that on the March 27th? Is that when that was?
Correct.
Okay. All right, thank you.
Ms. Wilner, can I also further to that point? There was a period of time where you refused to go out the front door to walk the girls, as we refer to our dogs, for a period of days, and instead restricted yourself to taking them out into our backyard. Can you describe what led you to taking that decision?
Yeah, it was around this time. Mostly when there had been shouting, it was either just sounds, not specific words, just making noise, or shouting that was between the two of them, but clearly meant to be loud enough for me to hear. The 27th is when they specifically made the comment to me, and that's also the same evening when Chris Tate had the interaction with them about the AR-15. And that was when I didn't feel comfortable going out and taking our dogs for a walk anymore, or spending any time in the front yard. They instead just let them out in the backyard, which isn't our normal routine. I usually take them for walks at least twice a day. I also recall it was at that time, I can't remember exactly which day it would have been. The Tuesday, Billy was outside on the property for the entire day and blaring the music, and that's our day to put out our garbage and recycling, and I know that we chose not to. I asked that you didn't go out and move them because Billy was there and didn't want to escalate things or have any interaction, that I said I would get up in the morning, hopefully before them, and get our garbage bins out to the road without having any confrontation with the people at 106.
Okay, and so in the interest of time, and given and I do hope that we will be able to have maybe another half an hour in the morning to wrap up. But can we move on to? So if I can summarize what you just said, Ms. Wilner.
No, you cannot.
Okay.
No, you cannot.
All right.
We're right now at the end of our day. It's, as I mentioned, we have to leave a little early or we get caught in downtown traffic. And she's done a good job. You don't need to summarize, and I'm not going to allow it. So you may have a little more time in the morning. We will, but not too much more, Mr. Wilner. Really, like I keep telling you that, but really. We have a 9:30 start tomorrow because we need to talk to some other parties at 9 o'clock. So we will be starting at 9:30. Mr. Wilner, 9:30 to 10 by 10:15, I'm going to expect you to have stopped. And then we're going to have to Mr. Savage is going to have his time. I think we will be able to get everything on tomorrow. And I just appreciate very much Ms. Wilner being here. Your testimony was extremely helpful, Mrs. Wilner. I know this hasn't been easy for you, and it's not easy testifying. I very much wish we could have wrapped up your testimony today because I know it's personally hard on you. But rest assured and try to sleep soundly tonight that you did a very good job today, okay? I'm going to admonish all parties, including Justin Chitwood, including Tracy Curry, that I don't want any retaliation against these your neighbors this evening or ever. We're in the middle of a hearing, and it would just really dig the hole much deeper to take any retaliation against Mr. and Mrs. Wilner or their property this evening. So I don't know who William Chitwood is, but if anyone talks to him on the phone, I don't want him around tonight. We are staying all status quo. I don't want any interaction between Chitwood and Wilner tonight. Anybody with the last name of Chitwood or Curry and anybody with the last name of Wilner. I don't want y'all talking tonight. I want you to stay on your own property. I don't want music over there. I don't want ugly thoughts. And I don't want any brandishing of AR-15s. If that should occur, it will be seen as a violation of a court order. Okay? All right. So with that, we're going to stop. And I'm sorry to be rough with y'all, but these are rough facts. And we've all had a hard day getting these out. So we're going to do that tomorrow. We'll be
Sorry, Your Honor.
for the I think I can see their case. They may have very strong evidence that shows something completely different. The court will certainly keep its ears open to that. I know that there's two sides to every story, and so we're waiting to hear from that. But like I said, any ability to or any effort to retaliate or intimidate this evening will be met with very dark consequences. All right. Any questions for me from anyone?
No,
Mr.
thank you.
Wilner?
No, Your Honor.
Mr. Savage? Mr. Chitwood?
No, ma'am.
All right, very good. All right, folks, so where you stopped. I hope you can too. So please go ahead. Please proceed.
Okay, so Ms. Wilner, on or about March 20. And I'm reading paragraph 14. Defendant Tracy Curry Chitwood allowed Billy Chitwood to
Okay,
use
slow. Remember, if you're
Yes,
reading,
ma'am.
you're going too fast. And the court reporter cannot write down what you say, so just slow yourself down a little. Okay, thank you.
On or about March 28, 2022, defendant Tracy Curry Chitwood allowed Billy Chitwood to use the property located at 106 West Wheeler to shout at and to intimidate plaintiff at plaintiff's property. These acts are reasonably calculated to cause discomfort or annoyance to persons of ordinary sensibilities. Can you describe the events that took place that day?
I can. It was the day after William Chitwood and Billy Chitwood had made the threats with the AR-15 while Chris Tate was there. And we had the worker here on the patio again, and you were outside with him. And William Chitwood shouted over at you using the N-word and other insults. Commenting.
You got to be a
about
little more specific than that. Okay, N word I get. Is this fat ass or is this another one?
A bitch ass, I believe he called
Bitch
him.
ass.
And
Okay.
specifically referred to William Wilner by name when saying that, and commented about how we had called the police on them and that nothing had happened, that they didn't do anything.
Okay. Your Honor, I would like to quickly offer into evidence in support of the witness's testimony P190.
Okay. And what is that?
This is a video capturing the event that the witness just described.
Didn't we already put this one in evidence?
No, Your Honor, this is another one still.
Okay. All right. Let's take a look at it.
One moment to share my screen, please.
Mm-hmm.
No, I apologize. Oh yeah, this is it. I would like to offer P190 as evidence in support of the witness's testimony, Your Honor.
Any objection, Mr. Savage?
Object on relevance. I haven't seen anything with any of the defendants in the lawsuit in this.
No.
This goes for, oh, sorry?
I agree with him. I don't see any relevance. It looks like 2 men and 2 dogs walking across the property. I know you are very familiar with it, but just as people looking at it, it just looks like 2 men and 2 dogs walking across your property. Okay.
Okay.
And keep in
Laura-
mind, like I told you yesterday,
Yes.
okay, your wife is testifying, all right?
Yeah.
This stuff just bolsters her. It doesn't make, I mean, she has offered powerful testimony. Powerful. This video that shows almost nothing, I'm confused as to where we're going with this, Mr. Wellner.
Okay.
So the objection is sustained. Please proceed.
Okay. Ms. Wilner, can you describe where you were when that incident took place and whether or not, and what, any other details or information that you want to add to your testimony on that?
You and the worker were in front of our door. I was just on the other side where I was working, where our table is. And Billy was across the street, William Chitwood, in his truck, which you can also see when he shouted those comments about the police not doing anything. And it seemed to me that he was saying that they were going to continue harassing us.
Okay. Thank you very much. Moving back to paragraph 15.
I'd like to request if we get a ruling on the objection, Your Honor.
I didn't hear your objection, sir.
I was objecting to the speculation for what she understood Mr. William Billy Curry Chitwood to be stating.
Yeah, okay, I didn't hear your objection, but now that I've heard it, your objection is sustained pertaining to William Chitwood's views on what was happening with the police.
Okay.
Please proceed, Mr. Wellner.
Moving on to paragraph 15. Ms. Wilner, on or about March 29, 2022, defendant Tracy Curry Chitwood allowed Billy Chitwood to use the property located at 106 to shout at, to intimidate, to threaten plaintiff and his wife at plaintiff's property. These acts are reasonably calculated to cause discomfort or annoyance to the person of ordinary sensibilities. Can you expand upon, or can you recount your experience on that date with that situation?
That was the day when we were returning with the groceries, and William Chitwood and Justin Chitwood were across the street, and he made the comment, I apologize for the language, about loving pussy and I wish I could dance in that. It certainly an uncomfortable thing to hear while I was walking by, and that definitely contributed to the not wanting to take the dogs for a walk and have any confrontation or have any further comments directed my way.
Do you recall if you made any comments to me in that exact moment, in the heat of that moment?
I just recalled saying that it made me uncomfortable and that I didn't like it, but that I didn't want you to do anything to speak with him or escalate matters in any way, that it would be better to just review the security camera and keep track of things rather than confront him about it.
And so I did follow that request of yours then. Is that your recollection?
That's true.
I apologize. I didn't mean to lead the witness, Your Honor. That was an inadvertent.
No, go ahead, please.
Moving on to number 16. On several occasions, defendant Tracy Curry Chitwood has been present outside mobile home located at 106 West Wheeler during the yelling, shouting, and verbal abuse. However, the verbal abuse can be clearly heard from inside the furthest rooms of Plaintiff's building at 202 West Wheeler, behind closed doors and double glazed windows. These rooms are approximately 200 feet from defendant's property and separated from it by the length of the building, a parking area, the width of the street, and two 20-foot city easements. On most occasions, the harassment occurs within 10 or 20 feet of the trailer home on defendant's property at 106 West Wheeler. Therefore, defendant Tracy Curry Chitwood could not have failed to hear the shouting and loud music from inside of her own residence. Can you share your comments and recollections with regards to paragraph 16, please, Ms. Wilner?
There have been a few times where I've seen her outside at the same time as William Chitwood and Justin Chitwood while they were yelling or making loud noises. There have been times where we've seen her outside on the same day when these things have taken place, even though she wasn't outside. As we said, we can hear it over in our property inside. There's certainly been times where it's gotten my attention and I've looked out the window or gone outside to see what is going on. And it's been shouting from them at their property. And if I can hear it inside at ours, then I can't imagine that she wouldn't also be able to hear inside of her residence there.
Okay, and can you describe the frequency of these events in comparison with the number of exhibits that we've offered the court?
We've shown just some of the incidents that have happened. There have certainly been far more that we haven't been able to show on video, and some that we don't have video of. You've been, when something would happen, we would, write down the date and time so that we could check the security camera to see that it caught it and download the video so that we would have in preparation for these things continuing. But it was certainly very frequent that things would happen. And certainly for quite a period of time, it was nearly every day, multiple times a day, that shouting would happen, or loud noises, or just extreme coughing that wasn't actually someone needing to cough, but just to make noise and draw attention, imitating being sick. And I try not to give them the attention to look over. I just continue about my way.
Were these incidents limited to any particular time of day or any particular days of the week?
No, it seemed to be just whenever there were people present that would be an audience for them. At any time that we went out, if it was morning, night, any day.
Did these incidents take place at all after the 10 p.m. city ordinance and cessation of noise?
Yes, there were times when driving the truck in particular around doing the burnouts. I do recall one time both of the Chitwoods were in the truck, I believe, and pulled into our parking lot to then back into their place, which there's no reason for. There have been times where Billy's been walking around the street at 2 a.m. in the morning, singing loudly. It's not normal behavior from your neighbors, and it's also, if it was a one-time occurrence, but on top of all of the other incidents that have happened and being given the judgment to not do those things.
Okay. Are there other incidents that you specifically want to describe for the court?
They're going to have to be in the context of your pleadings. Okay. We can't, I let this go on a little bit.
Okay.
You are pro se, but we're not, if you've pled it, she can talk about it. But if not, it's not supported by the pleadings. Okay.
Okay. Please disregard my last question, because that would be introducing another incident or two incidents that the witness felt were important, but which I have not introduced in the pleadings. So I stand corrected. I also will not ask to offer that evidence. How would you describe the impact of any financial sanctions so far, or the threat of financial sanctions with regards to modifying the actions or inactions of the defendants, Ms. Wilner?
It hasn't seemed to have any impact. When this first began, we had Justin Chitwood cited for foul language, and he was given a fine, which went unpaid. The judgment that we were given, there's been no effort to pay that. Financial penalties just don't seem to have any sort of weight. It seems that they just don't pay them. Even
Please go on. Do you have any other evidence that they don't care about financial responsibilities or obligations under the law?
Objection, argumentative.
Yeah, I think she's asked and answered. It's
Okay.
Mr. Wilner. I think you made your point with this. Okay.
Okay.
Objection is sustained. Please
Thank
go.
you, Your Honor. So how would you describe the frequency, the severity, and the criminality of the actions that were taking place after the judgment was rendered originally by the court, along with the injunction against the continuation of those activities? They're very specific.
She cannot speak as to criminality. She can
Okay.
talk about frequency and severity, but
Okay.
this is just her observation.
Please allow me to. Yes, I apologize. Please allow me to rephrase the question.
Yes.
And remove the criminality component. Ms. Wilner, could you please comment on the frequency and severity of the prohibitive activities described very clearly in the previous injunction after that junction was delivered and served to the defendants?
Both of those things, the frequency and the severity, both increased. All of the incidents, the shouting, it became a lot more frequent throughout the day, not just, once a day. It became almost every day that something would happen, and it certainly escalated. There was just the shouting that would happen and did continue, but then there were the weapons that were seen, the AR-15, the types of comments also became worse, as I said before. If it was just myself on my own, it would usually just be strange noises that were shouted, and then it became that comments were directed at me, or comments made about me. So it certainly it ramped up, became much more severe.
Did you notice whether or not there was any chilling effect on these actions or activities after they were served notice by SPAR process serving of the original hearing date for this matter that was originally scheduled for January 30th?
I think this has been asked.
In other words, this is a new matter with respect, Counselor. I'm specifically asking whether or not, when presented with evidence that they were going to be taken to court and with a contempt hearing, did even that measure, that service of that document, did that have a chilling effect? This is separate from the original default judgment.
Objection is overruled. I will allow the question. Please.
Your Honor, could I lodge one additional objection?
Yes.
He's alleged, I think he said the service of this petition for the contempt order has not changed the behavior, and that's not pled in this matter. I'm not sure that that's relevant to the petition.
I can respond to that. I'm asking the witness to describe her observations with regards to any chilling effect or lack thereof of communication from the court to the defendants regarding the severity.
So, Mr. Wilner, what's the relevance of this?
The relevance is that, and I'm not trying to give testimony on behalf of my wife, but
Well, it sounds like a little bit. What's the relevance of this?
well, the relevance is that every communication from the court has prompted a ramp up in poor behavior, in the behavior that is prohibited by the court.
All right. So what you're saying is that without the court taking further action, it's not, whatever has happened is not helping. Is that right?
It has not helped.
Okay.
Well,
All right.
I mean, I want to ask my wife that question. Has anything?
Yeah. I got you. I'm
Okay.
just trying to keep in mind, you're not talking to him. You're talking to me. I'm listening to him. He's talking. He has an objection. I have to rule on it. His
Yes, ma'am.
objection is saying not relevant because you haven't pled it. And what you're saying is, yes, it is relevant because it's showing that basically that whatever, damages or fines or whatever remediation the court has provided is not helping. That's what you're arguing. I agree with you. I think it is relevant, although there's going to be a limit to it. So go on and ask your wife those questions. All right, please proceed.
Yes. So once again, Ms. Wilner, what was the result of the latest communication to the defendants from the court leading up to the original hearing date of January 30 for these matters?
There was an incident I remember, and it was shortly before our original hearing was scheduled. It was in late January, and you had headed out to the car to check the mail, and Adrian Estrada and Justin Chitwood were on the 106 Wheeler property, and they had loud music blaring, and as soon as they saw you coming, they changed the song that they were playing to a different one that was the lyrics are F you repeated constantly, like those are the only words to the song, and it was clear that they changed the song because it stopped abruptly and then started with this new song when you were walking there. I was in the front around the corner and heard this change with the music.
Okay. Do you have anything else that out of respect for the court's time, and I'm very, very thankful for that. We do have those clips. I'm not going to ask to introduce them into evidence as
Are these the clip? What are these the clips of, Mr. Wilmer?
this, the incident she just described. We have that.
What date was this?
This was 10 days before the hearing date, but it's not in the pleading. I just wanted her to, and so I'm not going to. I'm adhering to the instructions that you provided.
Yeah, it's just, I mean, it's relevant. Let me just say this, Mr. Wilner. The testimony is provided is highly concerning to me. It is relevant for the fact that it appears that these folks are not listening to the court. Now, they may come back here in just a minute and say that's not the case. Here's what we think. That's what it's relevant for. I just don't think it's the pleadings support that incident, which is why in introducing an exhibit, your security cameras leave something to be desired. Let's just put it that way. We cannot really hear the audio on them. The video is not very good. So that's, I mean, but that aside, that incident has not been pled. It may show that they're not paying attention to what the court says, but in terms of here's something else we want you to find a contempt issue on, they have not gotten notice of that in your pleading. And that's part of their due process. So I think you've put on, some compelling evidence. They don't pay attention to you, court. They're going to come back and say, yes, we do. Here's why we do. But I don't think that you've given them notice of that. So let's go on and move on now. Okay.
So I won't bring up any more individual incidents. I think that, we've spent a lot of time, we've provided an abundance of information regarding the incidents that we chose to present in court. I will ask Ms. Wilner if you would, share the impact that this has had on your life, and in particular with your ability to start your own family. Please go ahead, Ms. Wilner.
I'd object. There's already been some testimony about her personal experience and how it's impacted her. So it's retreading on some ground we've been through. And I think it's also getting far afield of the question of, is there a violation of that injunctive order? And if so, what's the appropriate way to deal with that?
Yeah, I tend to agree with that. We have, we're not really here necessarily trial on the merits. We're not looking at, my understanding is damages as to the Wilners. We have certainly, she's put on, I think, very compelling evidence about things that she's changed. I mean, showing the severity of this, that she's, that we have and she don't want to walk her dogs anymore. She's afraid to go out the gate. We've had guests who, contract with a gentleman who was working to build the new Whole Foods. He doesn't want to be there. African-American guests saying they're concerned to be there. To me, that's pretty much within the scope of what you all have pled.
Okay.
Just getting
in that case, Your Honor,
starting a family from this, I don't know. It's a little bit more than that. But Mr. Wilner, tell me your response to that.
I believe that in my pleading, I did specifically ask the court for remedies. Although I did not, for damages. And I'm not sure whether or not this is the time to actually address what those damages are. But I would certainly, I would think that this type of an impact or damage assessment would be, this is certainly emotional damage, the delay of being able to start one of life's most important things in life. And if I'm incorrect, then I will humbly withdraw that. Out of respect for the time that's going by, I do want to proceed with the few remaining. No, I think I'm done with all the incidents that we've actually put in the pleading. Let me just double check.
Okay.
Would it be appropriate for me at this time to just ask the witness to share any other comments or thoughts that she wants to put before the court, or no?
Can't do that. No, can't do that. It has to be related to a
It has
question.
to be a directed question.
Yeah. Do you pass the witness at this point? You can ask for more questions if you want to after Mr. Savage finishes, but you are going, just as I stopped him from
Yes.
blowing the top off of, you're going to be limited in the scope to what he talks about. So make sure that you've make sure that you've asked everything that you need to ask Mr. Wilner. Now, if he asks something that you want more information on, you can.
With Ms. Wilner, with regard to the previous judgment, it's been alleged by opposing counsel that we have made no efforts to engage in a constructive conversation with them with regards to any sort of a settlement conference or negotiation.
I didn't hear that. I didn't hear that. Has he talked to you about this some other time, Mr. Wilner?
It's in, I believe it's in his reply, in his written reply.
Mr. Savage, how do you respond?
I'm not aware of having pled any 408. I'm not sure what he's referring to. I was actually about to object on the grounds of introducing 408 discussions.
Because of that settlement? Let's just move on, Mr. Wilner. I'm not
Okay.
sure that, but let's move on. Anything else for this?
I believe that that's it then, Your Honor. I'm not sure how to proceed any further at this
You've
point.
done a good job. You've done a good job. All right. Mr. Savage, do you have any questions for this witness?
Yes, thank you, Your Honor. Ms. Wilner, thank you for your time this morning. I understand it's difficult for you, and I appreciate you testifying today. I have some questions for you, primarily to understand who it is that is causing a lot of these issues for you. And so I'm going to go back to January 1st, 2022, I think New Year's Day of last year. And earlier I heard your testimony that you talked about William Billy Chitwood shooting some fireworks. Is that correct?
Correct.
Okay. And then during that incident, do you recall who else was outside with Mr. William Billy Chitwood during the fireworks on New Year's Day incident?
I personally only saw William Chitwood shooting the fireworks. It was another neighbor who saw both Justin Chitwood and Billy Chitwood, but I can't attest to that because I didn't see it myself.
But you don't remember seeing Miss Curry during that incident, is that right?
I don't recall.
On on March the 9th, I think that was the incident where there was someone banging on the door and woke you up in the middle of, or you were watching a show, I think, jolted you up. Do you recall that testimony from yesterday?
That was February 14th when we had the banging on the door.
Okay. And those individuals in that, you stayed inside during that incident, I understand, is that right?
Correct.
But you reviewed the video footage that we saw yesterday.
Right.
Those individuals that you saw, were all of those unidentified? I don't know if we know who those were in that video. Is that right?
I recognized two of the individuals during the occurrence. Adrian Estrada and another man who also lives at his property at 207. I do not know who the third person was.
Okay, thank you for clarifying that. When you say 207, is that the other property that is not Miss Curry's property?
Correct. It is the our other neighbor across the street the other way. We're on the corner.
And Mr. Estrada, do you have any information knowing where he lives or what his residence is?
He lives at 207 and he's frequently seen walking back and forth between his property at 207 and 106. Both Justin Chitwood and Adrian Estrada many times go back and forth between each other's properties.
I want to talk about the series of incidents in March of 2022. With respect to those incidents, can you clarify incidents during that time frame where you saw? Did you see Miss Curry during any of those incidents in March of 2022 yourself?
Yes, I did see her. Many of the incidents happened the second half of March, I would say. There were times when we have a large front yard where we often let the dogs run. So I would sit on the stairs while they run around, and I could see her come out onto her porch. There was a time specifically that I do remember her coming out when I believe it was both William Chitwood and Justin Chitwood returned in their truck, and then when they got out, yelled some noises. I can't remember if they said anything specific, but I do recall her being on the front porch in the front yard.
Okay. So that was one incident, right? Correct? Mm-hmm. Okay.
Correct.
Were there any other incidents where you personally saw Miss Curry outside the house during an incident that you have testified to?
We don't see her outside a lot. As you mentioned, we live here, we work for ourselves and work from home, so we're on the property a lot. So we don't see her come out all the time. Once in a while, we do see her sitting on the porch or in their front yard. I know that there have been days that we would see her out front. There was a chunk of time, like I said, the second half of March, where a lot of activity was going on, and there were days where we would see her in the front, and it could be the same day where the shouting happened. So we know that she was present, that she was on the property. She may not have been outside, but could have been inside the home.
Okay, thank you. Now, I understand in the series of March 2022 incidents, Mr. William Billy Chitwood did some things that were obviously very troublesome. I think we're not trying to raise that. Did Miss Curry engage in any of those acts that you've gone through regarding using offensive language, shouting, that type of behavior?
I don't recall when it was. I have heard her in an argument with Justin. There've been a couple times when that's happened. I've heard them arguing, shouting, using foul language. It wasn't specifically directed at me, whether it was shouted for my benefit or it just happened to be that way. I couldn't say, but I have heard shouting, arguing, and from her. Not nearly as frequently as some some of the other people that have been on the property.
Okay, well, yeah, I want to make sure I understand that distinction. Is it your testimony that Ms. Curry has not used any offensive language or any sort of foul language directed to you?
She has not. I have heard her saying those, using foul language. I did not hear, her call my name or say I hate you to get my attention when that happened. So as I said, I don't know whether it was shouted for my benefit to hear, but there was, as some of the incidents we heard with William Chitwood, who specifically called William Wilner's name or tried to get his attention. That hasn't been the case with her, that she didn't call my name.
With respect to the incident involving, I think what's been described as a AR-15 firearm, concerning that incident, have you ever seen Ms. Curry carrying any type of weapon? I guess specifically within that March 2022 timeframe, where there's those series of incidents that we went through involving Mr. William Billy Chitwood and Justin Chitwood.
I have not seen her with a firearm.
When you testified to the escalation of situations that have been happening, is it fair to say that that escalation has been happening from Mr. William Billy Chitwood and Justin Chitwood
I would say that yes, those two individuals in particular have gotten worse. There have been other people on the property as well. I mentioned Adrian Estrada. They're definitely the individuals who have increased their activities.
Okay, so wrapping up, in your view, would has Miss Curry ever done anything specifically to you that you find to be a nuisance?
The fact that it's her property, which she has control over, that there are these individuals who are spending all of this time on her property, that she's aware of these things happening and not putting an end to it, I do find troubling. That, she can hear the loud music playing for 8-10 hours the entire day as much as we can. If our windows and doors are shaking, then she could easily ask them to turn off the music, take the keys from the truck. The act of not doing something to prevent these things from happening is definitely causing a nuisance for us.
Thank you very much for your time. I appreciate it, and I understand it's not easy to testify. I have no further questions.
All right, thank you, Mr. Savage. Mr. Wilner, do you have any redirect for Mrs. Wilner?
You're muted.
Oh, wait a second. Before we go down this path, hang on just a second, Mr. Wilner. Mr. Justin Chitwood, do you have any questions for Ms. Wilner?
No, ma'am.
All right, thank you very much. Mr. William Wilner, do you have any redirect for Ms. Laura Wilner?
Yes, Your Honor, I do. Ms. Wilner, you've testified that Tracy Curry Chitwood is very frequently, if not almost always, on her property, not always visible because she spends most of her time indoors. This is your response to a question posed by opposing counsel. Can you tell us how she receives her food?
We often see deliveries that are left on the doorstep or the railing of the walkway. See cars that pull up with cases of water or bags of food delivery. Sometimes they stop in our parking lot and go across the street to make the delivery.
So, is it your contention that she does not even leave the property to run her own errands and do her own shopping?
Your Honor, I'm going to object. I'm not sure what the relevance of.
This is relevant. If she's home all the time, and what Ms. Wilner said yesterday was she was a shut-in, I think we get a little more testimony on this, Mr. Savage, and I will let her continue with this line of questioning. Mr. Wilner, please continue.
Yes, to repeat the question, is it your contention, Ms. Wilner, that she does not even leave the property to run her own errands or do her own grocery shopping?
We often see the deliveries, and we don't see her leaving the property. They had a SUV that was parked in the same position for months, if not a year. So we didn't see the car move, so she wasn't taking the car herself to go and leave the property, that it was in the same place.
Okay, for the record, Your Honor, that would be the beige Dodge Durango that was in the photograph submitted previously as evidence, showing the documents attached to the door of the trailer.
All right, thank you, Mr. Wilner. Please proceed.
Okay, and then just two more quick questions. You testified, or you answered opposing counsel's, Ms. Wilner, you answered opposing counsel's question about Tracy having arguments with Justin outside. Can you?
Tracy Curry, Justin
Tracy Curry Chitwood and Justin Chitwood on the property outside of the trailer, were those arguments limited to their property, or did one or either of them leave their property during the course of those arguments?
I don't recall them either one leaving the property when they were arguing with each other. It's possible that Justin Chitwood could have walked away. We do see him frequently, as I said, walking back and forth between the 106 property and the 207, but I have not seen Tracy Curry walking around in the neighborhood, but I don't recall at the time either of them leaving. I remember them being on the property when the argument happened.
Okay, thank you. And my final question for redirection is, in the injunction that was previously issued by the court, it very specifically specified, and I quote, or barred the use of abusive, indecent, profane, or vulgar language in a public place, and the language by its very utterance tends to incite an immediate breach of the peace. What is your understanding of that injunction, and do you feel that these incidents that you observed contravene that injunction?
I think, Your Honor, that's a question for the fact finder in this matter.
Right. It's not a question for her. It's a question for me.
Okay.
Mr. Welder, I'm going to sustain the objection. Okay.
Okay. In that case, Your Honor, I believe I'm finished with the witness. Thank you very much, Ms. Wilner, for your time and your testimony.
Thank you, Ms. Wilner. Mr. Wilner, do you have any other witnesses?
No, Your Honor, not at this time.
Okay. Do you rest?
Oh, yes, Your Honor, I rest.
Okay. Right. All right. Well, let's see. Sorry, go ahead, Mr. Wilner.
Just again, because this is not my bailiwick, with the ability to cross any witnesses presented, obviously by the opposing counsel, but I rest my case, Your Honor.
Okay. All right. There was one exhibit I had taken yesterday as conditional because we just didn't have enough at the time, and I let it in conditionally. Let me see if I can get back to it. It's P006, which was fireworks at the house. It's of limited relevance, somewhat relevant. So that is to the degree it was conditionally admitted, it's now admitted. Okay. And if there were any other exhibits around P006, the same ruling around which was the fireworks incident. We just hadn't had enough on to tell the relevance of that. And as I said, I think of limited relevance, but somewhat relevant. Okay. All right. With that, now, Mr. Savage, now let me just say this. We're about to shift gears here. We have about an hour. We probably end up coming back this afternoon. Now that it's the time for the respondents to put on their case, I am going to require Miss Tracy Curry and Mr. Justin Chitwood to put their cameras on. I was trying to kind of lower the aggravation factor while we had on the Wilners, but now that and most judges here would not have allowed that. I was just trying to kind of keep the peace here a little bit. Miss Tracy Curry, you're going to have to come on camera too. I see Mr. Justin Chitwood. If anyone needs a second to make themselves presentable, I understand that. We can take a short break. Ms. Chitwood, are you prepared to come on camera, or do you need a short break? Yes.
And Your Honor, I appreciate that quite a bit. I have obviously I don't represent Mr. Justin Chitwood, but I have instructed Miss Tracy Curry that she would need to be on camera.
Okay. Miss Tracy Curry, you prepared to come on camera, or do you need a break? We're having some problems with your audio. Okay, I'm going to do this. My court reporter, I'm going to take a short break. Ms. Guardiola, if you would please work with Mr. Savage, Mr. Wilner, Mrs. Wilner, you can take a short break too. Mr. Chitwood, if you need a short break. If Ms. Guardiola, if you would please work with Mr. Savage in terms of having his client call in if necessary. It sounded to me like we were having a real connection problem there, so it might be necessary for her call in. Thank you so much, Ms. Guardiola, Mr. Savage. We'll come back. It's 11:05. We'll come back at 11:15. Okay. All right. Thanks, y'all.
Thank you. Ms. Curry, are you able to hear us?
Yes.
Okay, great.
Mr. Savage, I think it'd be best if we had her call in because she's freezing.
Okay. Ms. Curry, I'm going to send you that Zoom call-in information.
I'm gonna send you an email.
Okay. I've got my email open. What in the hell is... All right. Well, as we're starting to come back on the record, we have a couple more minutes here, but I thought I'd check in with Mr. Savage. Any luck with getting better communication going?
Ms. Curry is on the line. We have her on a phone line. The video feed was freezing during the connection, but she is on a phone line.
Okay. Ms. Curry, we're not back on the record yet. We're still on a short break, which we all desperately need sometimes, including my court reporters. So tell me, can you hear me okay? Let's try it. Let's test the audio. Can you hear me?
Yes, ma'am, I can.
All right. Let's talk a little bit more because I'm getting a little bit of feedback from you. How about this? Ms. Curry, tell me what the weather's like today. How's the weather at your place?
From what I can tell, it's not too warm, not too cold.
Yeah. Okay. Now that's sounding better. I heard feedback the first time, but that last sentence
I
sounded
turned my volume down.
I gotcha.
So that it maybe wasn't causing as much interference with the microphone.
Can you hear me okay?
Yes, ma'am.
All right. Now let's go to Mr. Chitwood. Let's talk with you a second, Mr. Chitwood. Can you hear me, sir?
Yes, ma'am.
Okay. We've got a light bulb right behind your head. It's not too bad, but when you get away from it, sometimes we can't see you quite as well. Just they kind of make sure you're in the shadow of that. I think we're in pretty good shape here in terms of, being able to hear. Mr. Savage, are you able to hear all this without interference?
Yes, ma'am.
All right. Well, let's give it just another more minute here. My court reporter needs to come back in, and then we'll head back into the hearing. Let's just give it a couple more minutes. I just want to make sure we didn't step in there with still an audio problem. So I'll be back on in just a minute or two.
Thank you.
Right. I gotta remember to unmute when they should ask me something.
Ms. Curry, your microphone is on, just as a heads up.
All right, it looks like Ms. Gonzalez has returned from break 2, as have I. Okay, so here we are. Mr. William Wilner has just rested. Now, Mr. Robert Savage is going to put on his case on behalf of Tracy Curry, and then Mr. Justin Chitwood will have his opportunity to put on his case. So, Mr. Savage, I understand that your first witness is going to be who?
The only witness we plan to call is Ms. Curry.
Okay. Ms. Curry, you're on the phone. I guess we cannot see you. Is there no way to do the video too, I guess?
I'm not sure, Your Honor. Hit the camera button here. Good. You're unable to switch to video.
You are unable to?
When I hit the camera, it says it's unable to switch to video, Your
Gotcha.
Honor.
Okay.
Yes,
All right.
Judge, we have her calling in because her visual kept on freezing. So
Okay.
she's only available telephonically.
All right. We're just going to do it like that. All
Your
right.
Honor, if I may, I believe that Justin Chitwood and Tracy Curry Chitwood are simultaneously in the same residence. Since Justin has access to video, perhaps they might consider using that video for Tracy Curry Chitwood as well. Just an observation.
Okay, thank you, Mr. Wilner. Ms. Chitwood, the one thing that does concern me, or Ms. Curry, is I can't see you. I can't see you to swear you in. Is there any way you could go over to where Justin, I understand you and Justin need to both have your own link. Is there any way you can go to where Justin is so I can see your face and see your hand and swear you in? Is that possible?
Yes, Your Honor. I'll point the camera toward her.
Okay, thank you. All right, Ms. Chitwood, if you would please raise your right hand. Okay. Do you solemnly swear or affirm under penalty of perjury that the testimony you shall give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Ms. Curry, I'm going to ask you to stay at that camera while you can put your hand down. Can you stay at that camera and maybe Justin take over your telephone while your attorney questions you? It's pretty unusual for us not to question a witness and not be able to see their face. Is that
Okay,
possible?
we're gonna switch phones for a second.
That's good. All right, we're doing really well. Okay,
Turn your volume
All right.
up. I have a concern.
just make sure that camera is on your face because right now it's on the top of your head. Now we can see your face. Okay, very good.
I'm sorry, Your Honor. I do have hearing limitations, so I had to have Justin change the phone.
Can we get this fixed up?
Mr. Chitwood, I think your audio is on. Can you mute?
Yes, sir.
Ms. Courier, can you hear me? Curry, can you unmute your phone?
Okay, there we go.
Thank you.
All right, Mr. Savage, your witness.
Thank you, Your Honor. I understand you are Ms. Tracy Curry Chitwood, is that right?
Yes.
And you live at 106 West Wheeler, is that right?
Yes.
All right. And is that your home?
Yes.
How long have you lived there?
Since 1981.
And is it your primary home?
Yes.
Do you own that home with anyone else?
Just myself.
What do you do for a living?
I am on disability. I'm disabled.
Okay. So you're on Social Security benefits, is that right?
Yes.
And how old are you, Miss Curry?
60.
Okay. And you said you're on disability. You have some health issues as well, I understand. Is that correct?
Yes.
And I understand that you're at home. Oftentimes, do you stay at your house quite frequently as a result of some of these issues?
Yes, I do.
Do you have many assets beyond your home that you live in? Any financial wherewithal to pay court judgments, that sort of thing?
No.
Okay. I want to focus in on this default judgment, the reason we're here, and understand a few things about that. With respect to your relationship with Justin Chitwood, have you instructed Justin Chitwood to refrain from committing any acts reasonably calculated to cause discomfort or annoyance to persons of ordinary disabilities attempting to enjoy Mr. Wilner's property?
Yes, I have. And as far as I know, ever since Justin got the citation from the comment that he had yelled at Mr. Wilner, he pretty much refrains from speaking to him. We try to stay away from them, their property. We try to stay inside because we cannot go outside because Big Brother is always watching. We have no privacy. We go to our mailbox and pretty much come back in. Otherwise, we feel like we have to be recluses because no matter what we do, we are in violation of what we don't know.
Thank you, Ms. Curry. When have you told Mr. Justin Chitwood to refrain from these types of acts?
The day he got his citation, I don't remember the exact date, but I do remember that he told me that the police came by, issued him a citation for offensive language, and I instructed him on that day. And pretty much any time he goes outside, I say, remember, don't look over there, don't say anything, don't look in their direction, leave them alone, totally ignore them. They're nothing but trouble.
Why do you tell him this? Why are you communicating this information to Mr. Chipwood?
Because we have had nothing but trouble since the day he moved in.
And when you say he, are you referring to Mr.
I
Wilner?
am referring to the plaintiff, Mr. Wilner. It started with him taking all my mail out of my mailbox, returning it for the first 3 months he lived there to the post office. We didn't get bills, we didn't get anything because the post office said that our mailbox has to be on the easement of his property. They will not allow us to move it. We have inquired.
Objection, Your Honor.
What's your objection?
There's no evidence to support this. This is an
The
allegation.
United States Postal Service has a record of the complaint that I filed and told me.
Hang on. Okay, guys, here's the situation. I'm in a tough position here because I have to call balls and strikes. If you talk over each other, I can't do that. Now, Mr. Wilner, your objection was objection, no evidence. Stop. Okay. Ms. Chitwood is explaining why there is. So hang on. Mr. Savage is the one that gets to respond to that, not Mr. Hang on, Mr. Curry. Mr. Savage, how do you respond?
I think my questioning will move on. I was on a different question, so we can move forward.
Okay, the question is withdrawn. Objection is now moot. Mr. Savage, your witness.
And just to be clear, my question, I don't want to withdraw the question. It was just the answer exceeded what I was asking. So I need to make sure I'm able to ask the question.
Okay, ask the question. It's really hard, guys, when y'all are talking at the same time. Okay, so Mr. Savage, re-ask your question. Let's see if we can get an answer to it.
Miss Curry, why are you instructing Mr. Chitwood to refrain from this type of behavior?
Since he got a citation, we don't want any other occurrences. We don't want the police constantly over here. We try to, as far as I know, we try to mind our own business, stay indoors because we're uncomfortable going outside anymore.
Okay, thank you. With respect to other individuals, such as William Billy Chitwood, have you instructed Mr. William Billy Chitwood to refrain from committing any acts reasonably calculated to cause discomfort or annoyance to persons of ordinary sensibilities attempting to enjoy Mr. Wilner's property?
I have told Billy on several occasions to leave Mr. Wilner alone, not to go on his property, not to try to antagonize him, just to try to ignore him and to be as peaceful and to cohabitate in the same town, as peacefully as possible, that we don't want any more trouble.
And when have you instructed Mr. William Billy Chitwood concerning this admonition?
About the same time that Justin got his citation, I had spoke to Billy probably later on that evening and told him, look, Justin got a ticket for this. We don't want any more issues. When you do come over, please leave them alone. Refrain from saying anything to them. Don't, antagonize them. Don't go over there. Don't do anything. Just ignore them and leave them be.
Okay. I understand Mr. William Billy Chitwood is your brother-in-law. Is that correct?
Yes, sir.
In your view, have you attempted to stop him from engaging with Mr. Wilner and Mr. Wilner's property?
I have on several occasions, when I have seen him saying something, told him to shut his mouth, leave it alone, drop it. Billy is Billy. I can't physically control his actions. All I can do is admonish his behavior and get on to him about it.
Okay. You saw the videos that Mr. Wilner presented yesterday, is that correct?
Yes.
And in those videos, did you see yourself at some point, once or twice or none? How often did you say?
I had trouble making out anything that showed myself as the video was not clear. I could not distinguish one person from another in most of the videos. However, I did notice most of the videos had nothing to do with me personally.
With respect to the incidents that you heard the testimony to yesterday, do you recall being involved in any of those incidents? Do you recall being involved in those incidents?
No, most of them I pretty much saw for the first time when the plaintiff uploaded them into the box provided by the court.
Have you done anything to direct, other than the instructions you just testified to, have you done anything to direct Mr. William Billy Chitwood or Justin Chitwood to engage in any type of nuisance behavior with respect to the Wilners?
No, I have not encouraged them at all to engage in any type of any behavior other than to refrain from doing anything toward the plaintiff or his property, and to try to ask him to show respect and just to ignore the plaintiffs and go on with doing whatever it is that they were going to be doing, going wherever they were going to go.
In your view, have you personally done anything to cause a nuisance to your neighbors?
No, I pretty much stay here except for every once in a blue moon, trot across the street to go retrieve my mail and then come back into the house.
Your Honor, I think that's Ms. Curry's testimony. We tender.
All right. Thank you, Mr. Savage. Mr. Wilner, do you have any cross-examination of Ms. Curry?
Yes, I do, Your Honor. If I can beg the court for 30 seconds just to finish this note before I forget it.
Sure.
Okay. Ms. Curry Chitwood, I'm just have some questions for clarification based on the testimony which you have just given to your counsel. So in one of your first comments, you testified that due to health issues you could not control what was happening on your property. Can you expand upon that in the sense of how is it that having health issues would prevent you from exercising control over what takes place on your property?
Because I am not physically able to deter somebody from doing the said allegations in which you have made toward my brother-in-law. I cannot physically control another person's actions. I am not strong enough. I am not capable enough.
So would you not, as the owner, be able to trespass Billy from your property?
Also, I'm not supposed to have guests because it offends you.
That's not my
have somebody
question.
there because we don't go outside because everything offends you. So we try to stay indoors as not
Your Honor,
to offend
the
you.
combative
But
witness,
that
please.
even offends you.
Okay, guys. Time out. Settle down. Ms. Curry, you've heard the allegations here. There are certainly some things that you could see how the Wilners would be offended by. Just need to answer his questions as best you can.
I don't know, Your Honor, understand how he expects me to physically curb somebody else's actions. I cannot physically control another person. I'm not a puppet master. I don't pull strings.
Okay.
Okay,
These
my
are not
question,
puppets we are talking
Yeah,
about.
I got you. And you've answered the question. So just stop. You've answered it. Fizzle can't control the guy. Okay, go ahead, Mr. Wilmer.
so to restate my question, could you not have called the police or filed a trespass charge against William Billy Chitwood if he failed to
I
follow your
am not going
instructions?
to call
One
the
at a time,
police for
please.
somebody trespassing on my own property. He was not trespassing on my property.
Okay, here's the situation, Ms. Chitwood. My court reporter is trying to take down every single thing you say. So just try to say it in fewer words and more slowly, and we can get there. We're almost done. Okay. All right, we're almost done. You're doing a good job, but it's just we're in a slightly more formal proceeding today. All right, Mr. Wilner, please proceed.
Okay, so I understand that it's not that you could not call the police or trespass William Billy Chitwood, it's that you chose not to for whatever reason. Is that
I
true?
did not know exactly what was going on. I don't pay attention to every little minute detail of what goes on outside of my house. I have things that I take care of inside my house.
Okay.
I don't
moving on.
have a video in which to monitor 24/7 like you do.
Okay.
Okay.
She's answered the question, Mr. Wilner.
Moving-
Mr. Wilner.
Yes, moving on to another answer that you provided to your counsel, in which you stated that you had no assets to pay any fines or judgments. Is that true? That just to confirm that that is what you said to your counsel for the record?
I have already stated that answer, and I will leave it as what I have already stated.
She's answered that question.
Do you believe that, is it your contention that since you do not have assets, that you are under no obligation to be responsible for the financial obligations that are carried by being the owner of that property?
Objection,
I
argument.
believe I have already answered that question, Mr. Wilner.
Okay, I don't think it was argumentative. I think she's answered, and what her beliefs and what the court can do are two different things. So please
Okay.
proceed.
So earlier, your counsel asked if you had instructed Justin to not continue these prohibited actions and activities on your property. However, at the beginning of these proceedings yesterday, you claimed to the court or attempted to suggest to the court through your counsel that you were unaware of the injunctions that had been levied against you, requiring you to control what took place on your property. Can you clarify which one of these things were true? I mean, we've already established that you had been made aware of that. Did you make Justin aware of that again after you did in fact receive notice of the judgment that had been entered against you?
From my understanding, Justin has not done anything since he has received the citation.
That wasn't my question. My question was if you have instructed Justin.
I have already answered that question, Mr. Wilner, previously. I will not do it again.
I think it's a different question, Ms. Curry. Let me tell you what I think.
Honestly,
No,
what
okay,
he's
don't-
asking about the injunction, I don't understand it. It is very unclear as to what we can and cannot do, what we are allowed and not allowed to do. I'm not, from my understanding is we're not allowed to be outside because it will offend Mr. Wilner.
All right. Ms.
Okay, I
Curry,
don't believe that the
let's-
injunction.
okay, Mr. Wilner,
Yes, ma'am.
Mr. Wilner, let's everyone just take a second here. Take a deep breath. We're gonna get through this. We're gonna get through this. Ms. Curry, you're gonna need to answer the question. And if what he asked you was,
Then the answer would be,
No,
I
wait,
don't
wait,
know
let
because
me-
I don't understand the injunction.
all right, let me just rephrase the question as best I can. After you got a copy of the injunction, did you review it and give a copy to Justin? I think that's the question.
After I got a copy, I did go over it with Justin. After Justin got the citation from the police, from the complaint filed with Mr. Wilner, as far as I know and as far as he has made known to me, Justin Chitwood has refrained from having anything to do with Mr. Wilner other than going on his property to retrieve our mail. We try to stay away from him. We
Okay.
try to ignore him. We're doing our best.
Okay, all right.
But we
Mr.
cannot control the actions of other people.
Okay, got you. Mr. Wilner, please proceed.
Um, Thank you, Your Honor. Miss Curry Chitwood, can you explain to the court why, after you were due and properly served, and why, after Justin had already been cited both for vulgarity and for breaching the peace, when you were served with a notice to appear in the previous proceedings in 2021, why you chose to stonewall all communications from the court and refused to appear or answer any of those proceedings?
I never got date, notice, or time of when court was.
Okay, Your Honor, would like to point out for the record that that's not true. It was completed via Rule 106. Moving on.
All right, Mr. Wilner, here's my suggestion to you.
Yeah,
Okay, we're not here on the notice of that default judgment. It was taken, and she's already said that she's gotten full notice of what the court ruled
Okay.
in the default judgment. That whether the default judgment was correctly taken or not, that's not at issue today.
yes.
Stop the compound questions. Simple questions. That's all we can handle today. So if you'll do that, and then we'll make it through this. And try to keep it on what we're here on, which is your very powerful motion that she's already said she's reviewed, which is your first motion for contempt of court. Okay, so let's go.
Yes. I only have 4 more questions, Your Honor, for this witness. I'll try to keep them concise, bearing in mind that I wrote them as the testimony was being delivered.
You're going to have to break them into simple questions.
Yes, absolutely, Your Honor. I'll make my very best effort.
Okay.
Ms. Curry Chitwood, you testified that you told Billy to leave us alone and have nothing to do with us immediately after Justin Chitwood was cited for obscenity. What was Billy's response immediately thereafter?
I'd object to hearsay on that question. I'm not sure what.
Okay. Question withdrawn.
Okay.
You stated, and I'm quoting you here, Ms. Curry Chitwood, Billy is Billy. I can't control his actions. Oh, I'm sorry, Your Honor. I may have already asked this about how she did not call police or enforce her will on her property. You're facing jail. So you have testified that you were aware of the judgment, that you were aware of the consequences, that you went over it in detail with your son, Justin. So you must have been aware that you were facing jail time. Why did your refusal to evict Billy trump the possibility of you potentially going to jail?
What do you mean by evict? Billy doesn't live here. I cannot evict somebody who does not reside on my property. And your judgment is all full of legalese that I do not understand. So it's kind of hard to pertain to something that is above my head.
Okay, allow me to restate this for you.
It is confusing, and it can be taken several ways. Like I said, we don't understand what we can and cannot and are allowed and not allowed to do. That's why we don't go outside, hardly, because we don't know what we're allowed to, because we don't know what will offend you.
Okay, Mr. Wilner, I think she's answered your question. Please go ahead.
Okay. My final comment is one that, personal. My second to last question is, you claimed, Ms. Curry Chitwood, that none of the incidents that are at issue had anything to do with you personally. How do you reconcile that comment with the fact that you are the owner of that property? And the
Well, you're showing videos from 207. I do not own the property at 207. You're not showing videos of my property. You're showing it of Adrian Estrada and William Chitwood. I am not William Chitwood. I am not Adrian Estrada. I don't control them. And William Chitwood as my son's nephew. My son is going to continue. William, excuse me, is my son's uncle. My son is going to continue to see his uncle. He is going to continue to visit his best friend who lives at 207. Just because you want a big brother doesn't mean that friends aren't going to go be friends. They
All
come
right,
on
Miss-
my
Miss
property.
Curry,
We
Miss Curry.
try to stay away from your property.
Mr. Wilner, any other questions for this witness, or are you finished?
One final question.
Are you
Which is-
sure? All right, let's get it out there.
This is, I just want to confirm that the witness has confirmed on the record in her own words that she only ever leaves her property once in a blue moon. And so would you say, Ms. Curry Chitwood, that in fact then
You
our
know
assertion-
when I do and do not leave because you monitor me, big brother.
Thank you.
All right, there we go. All right, so,
We're finished. I'm finished with this witness, Your Honor.
okay, thank you. Mr. Justin Chitwood, do you have any questions for this witness?
No, Your Honor.
All right, very good, thank you. Mr. Robert Savage, do you have any redirect?
No redirect, Your Honor.
All right, thank you. Ms. Curry, I have a couple of quick questions for you. Are you mostly at the house right now?
Yes, ma'am.
Okay. And Justin, I'm sorry, not Justin, William Chitwood, have you explained to him that he can't come over if he's gonna not be abiding by that injunction?
Yes, ma'am. We told you, I have let Billy know that if he's going to continue to try to antagonize Mr. Wilner, if he's going to try to do things that offend Mr. Wilner, that he is not allowed to be at my property. I cannot control if he goes over to Adriana Estrada's property at 207 on the other side across the street from Mr. Wilner, where the fireworks were shot off. That is not my property. I cannot control other people's actions on other people's properties, which Mr. Wilner thinks I'm supposed to do. I guess I govern city. But I have told him, if you're going to, not follow by my rules and leave Mr. Wilner alone and not, say anything to him, not try to ignore him, then you cannot come over here. If you can behave yourself, then you can. But otherwise, I can't have you coming over here because it just causes too many issues.
So, Ms. Curry, we've seen some video and we've heard testimony that your, I guess, brother-in-law has been on your property, name calling, brandishing a weapon.
It was an airsoft pellet gun, Your Honor. The Manor Police Department examined the weapon in question. They determined it to be a CO2 airsoft pellet gun. I personally have never seen it.
Objection, Your Honor.
I'm asking her the questions right now.
Oh, sorry.
Mr. Wilson. You need to sit still and let me ask, because I'm trying to get to the bottom of what's going on here. Ms. Curry, so these things happened on your property. Did you explain to your brother-in-law, Mr. William Chitwood, that if he keeps coming around, the vice is getting tighter on you, right? There's a court order out there that is being violated by these actions coming from your property. Did you explain that to him?
I didn't know about half of them until I actually saw the videos that Mr. Wilner posted in his box at the beginning of this court when he submitted everything. Most of them I did not know. I did not know about Billy engaging with the airsoft gun. I did not know. I did not know about the pellets being shot till I saw the videos posted. I was totally unaware. Nobody had brought that to my attention. Mr. Wilner did not bring it to my attention that it happened. Billy did not bring it to my attention. Justin did not bring it to my attention. I did not get notice of half of the incidents till Mr. Wilner posted the videos.
So, going forward, the court's going to have some decisions to make today. Ms. Curry. And those decisions, there's quite a bit at stake for you. And I will tell you, in these types of matter, the heat starts getting turned up. Okay? So your brother-in-law, to the degree that he's coming around using racial epithets at the guest at this house, to the degree he's coming around and calling ugly names to the Wilners, calling him, bitch ass or fat ass or whatever he's calling him, calling.
That was not done on my property, Your Honor. That was done across from 207, across from Adrian Estrada's property. I have no control of what Billy does in the middle of Caldwell Street and Wheeler Street.
Okay, I don't know where. Okay,
it was not on my property.
You need to listen to me for a minute. I'm sorry. This is my job right now. Some of it was from your property, and we can see that from the camera, to the degree that he's blasting music that says F you, F you, F you, that they can hear all over the house. These types of things that your brother-in-law is going to have to stop coming around if he cannot abide by this court order, because it's coming back to you and it's going to affect you. And that's what you need to understand. And I got it. I'm not as young as I used to be either. But you're going to have house rules, and he's not going to be able to come around if he's going to not be able to abide by these things and not harass the Wilners. I mean, that's just kind of where we're going with this today. Now, I don't know what my order's going to be. I'm not going to have another chance to talk to you directly, but I want you to be very, very aware of that, okay? That this is not a game. It's not funny. It's not a matter of, oh, I can't control it. You're going to have to figure out some way to rein this in. Because these things, we're kind of the heat's up today. It's probably kind of at mid-level. It's going to get hotter. And that's not going to be something that you're going to be able to control much anymore. So it's time to lay down some house rules so that the Wilners are not afraid to go out of their house with their dogs. I mean, this is so that their guests aren't afraid that they're going to get shot. I mean, these are some issues, and they're coming from your property. Now, I understand you're not the one doing it. It doesn't even look like Justin is necessarily the one doing it. But to the degree that Billy Chitwood is coming around, the fact that Justin needs to see his uncle, I totally get it. I totally get it. It's very important for families to stay together. But there's some house rules, and people are going to have to obey those house rules. It's not that you cannot step your foot out the door without the Wilners coming after you. There's some very specific things they've alleged that are very concerning to this court. So I just want you to be clear on that. And I'm not angry with you. I don't know you. I get where you're coming from. I'm not as young as I used to be either. Sometimes people pull things over on me, but I sure want to know about it if that bad problem is going to end up at my doorstep. And Miss Curry, I'm telling you, that bad problem is coming to your doorstep. So it's time to lay down some house rules. I just want to make that very clear to you. All right, that's all I have for this witness. Mr. Savage, do you have any, Mr. Justin, I think we're finished with this witness. Is that right, Mr. Savage?
That is correct, Your Honor. Thank
All
you.
right, you may step down, Ms. Curry. Do you have anybody else, Mr. Savage?
Ms. Curry rests.
All right, very good. Now, Mr. Justin Chitwood, would
Yes,
you
ma'am.
like to ask any questions today? You're representing pro se, meaning you don't have an
No,
attorney.
ma'am.
You have any questions? Anybody you want to talk to?
No,
Anything
Your
you
Honor.
want to say? All right, very good. All right, you were not on either other witness list. I think at this point, Mr. Savage, do you rest?
Yes, ma'am.
Mr. Justin Chitwood, do you rest?
Yes, Your Honor.
All right, very good. Now, at this point, I'm going to allow it's 11:52. So I do have to go somewhere at noon today. Do we need a closing statement? If we do, we're going to have to come back after lunch and do short closing statements. Okay.
Yes, Your Honor.
Okay. Well, I'm going to try to rule this afternoon, but I'm going to take a little break because I need to go over evidence somewhat. What I am going to allow is each side to 15 minutes. Okay. 15 minutes. So, Mr. Wilner, you start putting your remarks together. My suggestion to you is to go back to your pleading and what you've alleged and try to show each of the pieces of evidence that you've seen that supports these things. Mr. Savage already knows this because he's an attorney. Okay, and I'm going to allow, since Mr. Wilner, since this is your case, you can go first and you'll put on your closing. Mr. Savage, you can go second. You can either use all your time and if you need any, no, I'm sorry. I got it backwards a little bit. Mr. Wilner, you can go first, and if you want to say 5 minutes for rebuttal with Mr. Savage, you can, okay? So you can go 10 and 5, or you can use all 15 up front, okay?
Thank you, Your Honor.
It's gonna be, it is gonna be timed. All right, so we have that. Now, I would ask that Ms. Tracy Curry, Mr. Justin Chitwood be back here as well. At the end of this, Mr. Justin Chitwood, if you'd like to make any remarks in closing, you will be allowed to do so because you're also a party here. All right, is there anything else before we take our afternoon or our lunch break?
No, thank you, Your Honor.
Mr. Savage, all right. All right, well, let's come back at 1:30 then, and we'll wrap this up, and then the court's gonna take a little break, and we're gonna come back and issue a judgment, and I'll expect everyone to be here for that as well, okay? All right,
Thank you, Your Honor.
all right, thank you, bye now. Thank you.
No, you know the issues. Yeah, thanks.
Hello. Diana, can you let them in the back know that I need the files on Mr. Featherston's case? Thank you. Oh, Featherston's. Yes. Yes. Well, I need Featherston's client. Thank you. And I need to make sure all of his motions are in there. Well, today is Wednesday, but for some reason it feels like a Friday. And the case on counsel, the case on Rios, I guess, they found it for me, Caroline. Thank you.
Oh, they got it.
Yeah.
Oh, okay.
The case on Rios,
Yes, Your Honor.
are you doing the motions for the aggravated assault?
Yes, Your Honor.
Okay.
It appears to me there are no more cases.
Okay. All right, and state, is that being dismissed?
That's what it looks like at this point, Your Honor. I haven't the final decision, but it is.
Okay. Good morning. Okay, this is Jason. This is the first time I've seen you come in with a mask. What do you have to tell us?
Just like an error of history. I woke up this morning, I had a bit of a stuffy nose, a bit of a sore throat, and a bit of a headache. They're all very small, but in case I'm getting sick, I just don't want to spread it around.
Thank you so much for that. Other people just come in and they breathe over everybody. My mom appreciates that. All right, so Mr. Martin Lee Rios, everyone just let me know when you're ready. I don't know, Mr. Ferguson, if you and Mr. Garahan had a chance to conclude
review of their motions?
For which one, for Rios?
Rios.
Yes, I just gotta grab it out.
Okay.
Judge, do you want us to sit at the tables or up in front or
Oh, whichever is most comfortable for you all. I think the motions are they lengthy?
I just need a place to be able to write as you rule.
Okay, if you don't want to sit down, that's fine with me.
Up to you. Sit up here. Let's just do it up here, I guess.
Oh, I don't know if you want to. I don't know if the court reporter wants people hovering over her.
Oh, she doesn't? Well, goodness gracious. I thought I was good looking. I'll sit back here, Your Honor.
All right, and if we can have your client come over.
Okay, that'd be good. Sorry, Steve. Go ahead. Let's see right here. Okay.
It won't work.
No,
Your Honor, if I may inquire, do you have a copy of the motions now?
Yes, I'll call the ones out that I have, and we can proceed on them as I have them, if that's okay with everyone. All right, Diana, Mr. Featherston wanted to put his notebook and everything right in your area so that he could write things down. I told him no. You know what my mom always says? No is a complete sentence. I'm like, okay. But it's Wednesday. It's going to be a great day. All right. Court is going to call 2022 CR 10144, State of Texas versus Martin Lee Rios. Can I have parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense?
Robert Featherston, Your Honor.
All right. And are you Martin Lee Rios?
Yes, ma'am.
All right. So we're here. Defense, you have motions. The first motion I have is a Brady motion for criminal records of state's witnesses and co-defendants.
That's correct, Your Honor.
All right, state?
Yes, I'm sorry, Judge, would you like me to respond to it?
Yes.
Okay.
And you can, and both parties, you can remain seated.
Thank you.
I don't take that as a sign of disrespect. It's easier for the microphones to pick up so I can hear better.
All right, good. I'll try to speak up. On this one, Judge, I did talk to Mr. Featherston about it. State does supply the TCIC in the file, and I believe he was in agreement with that, that if we had any issues with it, that he would bring it up to the court, or bring it up to the state, and we would supply it. We don't make copies, and we don't upload that to e-discovery for purposes for the state, but I think we're in agreement on that.
We are, Your Honor. As long as I have access, I'm good.
All right, and the court is aware that certain documents you're not allowed to make copies of. So what I'm going to write is I'm going to grant the motion, and what I'm going to say is that the defense is allowed to have access to the criminal records. And let me write this in. And you also have in this motion, defense, that this material is to be given to you by a certain date and time. I'm assuming that that's no longer needed. Is that correct?
Judge, today's just fine.
Okay. State, are you okay with today?
If he needs access to it, he just has to get it to me, Judge, and I can give him access.
Okay.
Now, the last bit of this hearing. Let me find it. Okay. I am it is. Let me see. Okay. Oh my gosh. Oh my gosh. Come on, the Chitwoods. Feel bad for the Chitwoods. Having to have Wilbur as their neighbor. That part sucks. Where, oh, where is the ending? Where, oh, where is it now? Okay, there we go.
Comments with racial epithets, with brandishing of weapons. These things have made it so that the
Okay. I think this one first.
not give. Let's start out with the original injunction that, or default judgment, injunctive relief that was signed back on August the 23rd of 2021. This injunction does not allow us to take anyone's home. Okay. It's jail time. It's a fine, or it's both. Okay. And I will say, Mr. Savage, that a lot of our time is spent deciding whether or not jail time is appropriate right now or not. The acts that we've seen are unconscionable, intimidating your neighbors to the point that they're frightened, with ugly sexual comments, with racial epithets, with brandishing of weapons. These things have made it so that the Wilmers do not have quiet enjoyment of their property. Ms. Wilmer is afraid. She's afraid to go out the door. Okay. That's where we stand right now. And that's more than just as a how they should talk to each other. Okay. And honestly, Miss Chitwood, there was a lot of testimony here that she's home all of the time. And in fact, we have her there on the 24th. We can see her out in the yard. On the other times, you'd have to be turning a blind eye to miss the other things that we notice. Now, it seems we've lost your client, and I need her to come back on here. Is she still there? Miss Curry Chitwood, are you still there?
Ma'am, she's right next to me. She can hear everything.
All right, good. That's good. All right, so here's what we're going to do. We're going to impose a $4,000 fine. That's $1,000 for violation, referring again back to plaintiff's first motion for contempt of court, for enforcement of previous injunction, and for permanent injunctions and foreclosure of property. That's for violations of 9, 12, 13, and 15. So that's what we're doing. Now, there is no contempt on Justin Chitwood. We did not find that he had engaged in these. He might have been a tag along with his uncle. We did not see any evidence that he had engaged in this property. His mother does own the property. Now, Mr. Chitwood, please keep in mind that under that original default judgment, you and your mother are jointly and severally liable for a $56,000 judgment. It's high. So just to keep that in mind, I suspect that's a number that seems pretty much impossible to pay. It will have other implications though, so please be aware of that. Now, to Mr. Savage's point, that the default judgment was not specific enough. That was a judgment signed by Judge Connor back in August of 2021. If there's some misunderstanding about what that default judgment means, the local rule requires you to go back to Judge Connor and request a clarification of that judgment. This hearing is not the right format for that. I did see that you had some post-judgment issues that were still, um, percolating there. Here's what I'm gonna do. As you can see, we don't have jail time. The one thing I did not recommend is jail time. And let me tell you, we did talk about it. And I know that's probably very frightening to Ms. Courage, what is it would be to me. This is your first time in court. I don't think we're there yet. But that doesn't mean that the next court won't find that. Okay? So that still could happen. But what I'm hoping is that we see that while this could happen, it doesn't have to be that way. All right? So here's what I'm going to order. I'm ordering both parties to mediation. Okay? And you can agree on a mediator, and this is Mr. Justin Chitwood, Miss Tracy Curry Chitwood, and Mr. William and Laura Wilner to mediation. I want you to either agree on a mediator, or you can use the Dispute Resolution Center here in Travis County. It's low cost mediation. Each side are going to pay their own cost in this mediation. Okay, so that so cost is a factor, and I want you both sides to show up in good faith. I will say that I suspect, just looking at the property that we've seen, that the Chitwoods are probably judgment proof. That doesn't mean that it can't affect their credit score, and it doesn't mean that it can't cause other problems for them to have that judgment out there. I do suspect, although I don't know, that what the Wilners really just want is the quiet enjoyment of their property. They just want to be able to have their guests there and to not have ugly, racist, sexist terms thrown across their property, golf clubs slung around, AK-47s brandished. You know, they just want that. So I think there's room to meet here. And I think there's room for both sides to come together. And that's why I'm ordering this case to mediation. Now, you do have some post-judgment matters percolating. I do suspect that this might be a pretty good time to try to get the case mediated. So I'm going to give you all 60 days to try to get this case mediated. All right. Now, those are my general views on this case. There's some other observations I have here, and let me start with Mr. Wilner and Laura Wilner. You won't need an attorney. You're doing a good job, but you need an attorney. This is very difficult for you to do this on your own. I don't want to hear from you right now. Put your hand down. You need an attorney, you need better cameras, and you need a fence. Okay? And maybe not in that order, but I think attorney's at the top of your list. I don't want to hear from you. Now, let's talk to Miss Curry Chitwood for a minute here. And let's talk to Justin Chitwood here. I do think that it's extremely impressive from you, Mr. Justin Chitwood and Mr. William Wilner, that you didn't take this fight up out there in that side street, that you brought it to a courtroom. I will tell you that when you've got guns around, when you've got military people around, and when you've got ugly words being thrown around, ugly fighting words thrown around, the courtroom is not usually where these disputes end up, and they often end up with people not standing at the end of them. So I congratulate both sides for that. I do think Mr. Justin Chitwood has shown some restraint around his uncle. My hat is off to his uncle for coming around for him. I think that's good. But it may be that the best solution here, folks, because you're now facing a $4,000 fine because of this, is for you, Ms. Tracy Curry Chitwood, to lay down the law and say that Mr. William Chitwood not come to the house anymore. He's causing you too many problems. Now, I'm not saying that he can't stop those problems. I'm not saying in the future that he might not reform. But right now, wherever he is mentally or psychologically, is costing you money. And that's not what you want. And it's costing the Wilners the quiet enjoyment of their property, which is not what they want. So I think that that's an actor here over which I'm not saying puppet master, but sometimes the owner of a house just has to say, this is my house, and you're not coming around until you can behave yourself. That may be what needs to happen here. So that's where we are today. I know it's not as much as the Wilner wants, Mr. and Mrs. Wilner wanted. I know it's probably a lot more than the Chitwoods wanted. But that's where we are. $4,000 fine. This is on Ms. Tracy Curry Chitwood, not Mr. Justin Chitwood. Although please keep in mind that the Chitwoods are jointly and severally liable for the $56,000 in the original default judgment. I'm ordering mediation. Both sides are to pay the mediation, okay? And you will be attending. As I mentioned, Dispute Resolution Center is often a source for inexpensive mediators. I will say that I think that all the money that we bandied around in this, the 56,000, the 4,000, I don't know if you'll ever see who will ever see a penny of that. I don't know, but I do know that having that type of judgment out there, it's it is a hammer that comes back very hard in the future. And this is what we need to be aware of, and why Mr. Wilner needs to get an attorney. This is beyond the scope of a layperson. All right, with that, Mr. Savage, I'm going to ask you if you would please draft a judgment up. I would ask you to please run it by Mr. Wilner first. Mr. Wilner, if you can hire counsel before the mediation, I cannot order you to do it. I can only suggest. I am suggesting. Mr. Savage, I would like you to take the lead on trying to locate a mediator and see if you can find somebody who would be amenable to both Wilner's and to Mr. Curry's. Okay, I can hear you right now, Mr. Wilner. So I would ask Mr. Savage to please take the lead on drafting your order and please taking the lead on setting it for mediation. I do think that, to the degree that we can, Mr. Justin Chitwood can continue to try to be a moderating influence, I think that would be very helpful. And we are going to try hard. Mr. Wilner, you need to settle down because we're doing a lot for you right now, okay?
You hired counsel and they stole a $12,500 retainer from us, and we're currently at small claims court trying to recover the retainer that we paid to a law firm to represent us. We had no choice but to represent ourselves.
I got you. I hear you 100%. Okay, I can't help you. I'm just telling you, there's some things here that you're not doing and I can't help you because I'm not your lawyer. You need a lawyer. So that's all we can do here. There's a line over which I cannot step. All right. Okay, so that's what we have today, folks. And I know that folks are probably, again, not getting every single thing they wanted. But I do think it's time. I'm not saying get Mr. William Chitwood out of anyone's life, but maybe go meet him at his place. Maybe go meet him at McDonald's. Maybe go meet him down the road, but not at the house where he seems to not be able to step out of his truck without yelling racial, sexual epithets at people that are causing him to be frightened. Okay? That's where we are today. All right, so Mr. Savage, is that pretty clear in terms of the order?
Yes, ma'am.
Very good.
Let me ask the court how I go about filing an appeal. What's the process?
That's not I cannot. This is why you need an attorney. So, all right. So this is where we are today and as I said, we don't have jail time up there right now, because it is their very first day these folks have had in court. But Chitwoods, please be advised that the next time you're up here, you probably won't be in front of me. The judge may feel very, very differently than that. Okay, so I just need you to be aware of that. And Mr. Wilner did not ask to have your property closed, or it was not ordered in the default judgment, which is now final judgment. That's not saying it couldn't come back in the future, folks. It might not, I don't know, but I just need Chitwoods to be really aware that while a $4,000 fine is pretty unpleasant, it could have been a whole lot worse today. So now's the time to cool things out. Okay.
Your Honor, may I ask for consequences to be attached to the defendants failing to adhere to the judgment that's being issued by the court today, please? If they do not attend the mediation in 60 days, if they do not pay the $4,000 fine, then
my order is my order. Okay, so let's go from there. All right, folks, that's all I have, Mr. Savage. If you would please draft an order, get it to Mr. Wilner to look at as quickly as you possibly can. We'll be signing it later on today. And that's all we have. Mr. Justin Chitwood, I appreciate your help today, sir. Mr. Wilner, Ms. Wilner, very good job putting on a case. Mr. Savage, thank you very much. I know it has not been easy on any of us today to get through this, but we seem to have, and I hope I've given you all something that is a starting place to get this resolved. It is time to make this smaller. It is not time to make this bigger. It is time to make this smaller. Okay, so let's keep focusing on that. It's time to get this resolved. Okay, let's see. Hang on a second.
Likewise, Your Honor, for your guidance, we appreciate it.
Yeah. Do you, I know you're gonna need some time to get this drafted, Mr. Savage. It's gonna take some time. So if you would, how much time do you think you need on it, sir?
I want to talk on my client side, but I obviously want to put this at the top of my stack. So,
Yeah.
but I can get started on it and try to get a draft to Mr. Wilmer tomorrow.
Okay. Well, I'll tell you what we were looking at was also Civil Practice and Remedies Code 1125.002, which is on suit to abate certain common nuisances, and that was it was certainly a guiding factor on some of these issues, and I hope that's helpful as well. All right, okay, so that's kind of where we are today. As I said, I hope that no one needs to wait for any. Please don't wait for any of these things. Please now, Chitwoods, please stop the degree that William Chitwood wants to come around. I think it's costing y'all too much money and it's causing your neighbors too much consternation. It's time to cool that situation out and whatever it takes to do that. Okay. And I don't know you all. I'm just telling you that's my observation. All right, folks, that's where we stand today. And with that, we are adjourned. All right.
Thank you.
Thank you.